Hey everyone, it's Rob Stanley with the EcomWhiz podcast. Today's special guest, who's been on the show before, is Jeff Schick. He's an e-commerce attorney from ecomattorneys.com. Jeff, thanks for being on the show. I really appreciate it.
Thanks, Rob, for having me. I really appreciate it too. Hopefully we can share some cool knowledge with all the subscribers.
Yeah, so last time we had Jeff out at our FeedbackWhiz office, and we did a meetup and it went great. And I took all his audio info and put it up on our podcast and got a lot of people actually commenting on it and listening to it. So I figured, hey, new year, let's do another follow-up. And we figured this year, though, we're going to talk a little more about how to kind of keep your account from getting suspended, your Amazon account from getting suspended. So one of the first questions I want to start out with, Jeff, is what is the issue? Like, who Amazon sellers are contacting you regarding legal issues? What's kind of the number one issue you're hearing right now, and how are you dealing with it?
So the number one issue we've been helping sellers with is intellectual property complaints. So sellers are getting kicked off Amazon left and right because of either copyright complaints, counterfeit complaints, which usually are trademark related, could be trademark infringement complaints, and then the last two big ones are design patent and utility patent complaints. So all those grouped together, we categorize as intellectual property complaints. And that's the number one reason we're helping sellers right now with suspensions, because it may be bogus. Like in the case of retail arbitrage, a lot of our sellers in retail arbitrage have false counterfeit complaints, or it may be legitimate or illegitimate, depending on, for private label sellers who oftentimes are unaware of what intellectual property rights actually are and what they might be unintentionally violating or being accused of violating by a competitor. So.
Yeah, so that brings up a good question, because you're talking about retail arbitrage. So a couple of weeks ago, I was in New York for Ed Rosenberg's show. Yes. And Ed actually had somebody from Amazon there on stage and asking questions. And one of the questions Ed asked was basically regarding like, you go out, you buy something in retail arbitrage, you send this receipt, and sometimes Amazon will like balk at the receipt, like thinking it's fake or something. So, I mean, is there any way to kind of like, I guess the right word is like, be careful where you shop at, like, because, there's discount stores all the time, and you assume that the items you're buying for retail arbitrage from these discount stores is going to be legit, and you got the receipt to back it up. So what happens in a case like that? Like, is that something that I would come to you about, or do I deal with Amazon directly on that?
So it depends. Sometimes you'll go to Amazon first and try. But they don't always accept the documentation, or there may be other stumbling blocks, in which case then sellers come to me. And so I help a lot of retail arbitrage sellers, and especially with the documentation, getting it to the right person at Amazon so that it gets reviewed and accepted. Amazon still accepts receipts. So if you're shopping at a Walmart, Home Goods, TJ Maxx, Marshalls, any of the outlet stores, those are totally fine. The issue comes up if you're buying from a liquidation company, for instance. Liquidation stores, Amazon's not so keen on. So unfortunately, goodwill arbitrage, they don't accept goodwill receipts. The reason being is pretty simple. A lot of sellers, they don't understand it. They think Amazon is being elitist. But it really comes down to, if they started accepting goodwill receipts as proof of authenticity, then you would have this just influx of donations at Goodwill of counterfeit products, most likely at the Port of Los Angeles. And then it'd just be, and then you'd have these massive retail arbitrage groups going to Goodwill and just buying products back from Goodwill that were previously donated, and then sending them in and saying that they're authentic. Obviously, it would not be authentic product. And so the reason, that's why, with Goodwill, there's no way to prove the supply chain. But Amazon, as long as it's a reputable store that you can prove supply chain authenticity, any of the standard bricks and mortar stores that are name brands, Amazon's going to be fine with. It's the smaller businesses that sometimes you run into issues. But the nice thing about Amazon is, say, if you go to one of these mom and pop shops, like say you go to, Discount General Store, of Sacramento, and it's, a small mom and pop company, and you tell them what's going on. A lot of these store owners will, they don't want to, but if you talk to them and you say, heart to heart, my business is being held up by Amazon because I purchased these products from you and Amazon doesn't know who you are, they will often give you their wholesaler's receipt. So you'll even, they may tell you, you have to promise you're never going to contact the wholesaler directly and try to cut them out, but it's a fair trade to be honest with them and give them your word that you won't do it. And Amazon will accept, multi-levels. So we've gotten sellers back on by providing, here's the seller's receipt from small business A, small business purchase from small business B, mid-sized business B, who purchased from national distributor C, and provide all those supply chain receipts along the way. And Amazon then reinstates the account and accepts the documentation. So it all comes down to trustworthiness of supply chain.
Yeah, no, that's perfect. And I mean, so like you just said, you got to show the path going back is basically, right? Where it originated from and how it got there. So that way there's proof to say that it's a legitimate product. Yeah. Now, what about let's say you're over in China, you're going to these factories, you run across a product and you're like, man, this would be great to sell, or, hey, this has a brand name on it. How reliable is it buying from some of these factories, some of these products that have brand names on them, and you're obviously going to give Amazon a receipt showing, or invoice showing that you bought this from a factory. But I mean, how many times does that hold up?
Never.
So
that wouldn't. So if you're purchasing from the product from the manufacturer, and it I might go to the Apple iPhone, the company that's making iPhones. I think it's Foxconn, right? If I'm not mistaken. Yeah. So I might go to Foxconn and say, hey, I want to buy iPhones from you. Even though they're making products for Apple, the second they make the same product for you and put an Apple logo on it, it's counterfeit.
Yep.
So a lot of sellers don't understand that, where they're like, oh, well, they're just selling me factory seconds. Only Apple can sell you factory seconds. If they're buying factory seconds that bear another company's trademark, that's considered counterfeit.
I'm very familiar with this, especially the Apple world, because that's where I came from.
That's right. Yeah. No, now I remember that because.
So the way, just so you know, what we did is we found let's say screen or battery suppliers that supplied Foxconn, went directly to them, had them make one specifically for us, obviously without Apple's logo on it, without any naming on it, just a generic screen. And you are allowed to sell that. You're allowed to sell replacement parts as long as you're not and just to be very careful on this, you need to be careful on the way you title it, the way you describe it, and even the condition of it. So I went quite a few rounds with Apple to make sure that when our website was selling stuff that it was okay to sell it. And that'd be a little recommendation is, if you're going to sell something, even a replacement part that doesn't have the name or trademark on it, sometimes, and you may not always, but use somebody like Jeff to maybe contact the corporation and find out what wording is correct that I should use, or how can I sell this as a replacement item, but it's not an original part. So
No, one of my neighbors is launching a private label brand, and they make auto parts, or they're going to make auto parts private label. And the first thing I was telling him is, when you start selling these, it'd be compatible with Ford F-250. It's not a Ford F-250 wheel. It's compatible with the Ford F-250. Because the second you start making it look like it's an official Ford product, you're bordering on trademark infringement or potentially counterfeit, depending on what you're selling.
Absolutely. In fact, I remember correctly, there's actually one of the public pages on Apple's site tells you the wording you can use. Yeah. It's been a while since I looked at it. It's been actually 3-4 years. But if I remember correctly, it was like battery for iPhone XYZ, whatever it was. You had to start with that word. You couldn't say iPhone XYZ replacement battery, even though replacement is a good word to use, which you'll want to use that. You have to say replacement battery for. And for was always that key word that they had told me. Anyways, not to get too much off subject. Let's go into some details though.
With Apple stuff, you also have to watch, you can't use made for.
Made for, correct.
You cannot use made for.
You cannot not use made for, yes. That is absolutely correct.
It's a special one you have to pay a fee to use. So.
Yep, absolutely. So let's say I'm in Canton Fair, or I'm over in China and I'm walking around, and I don't know, let's give it a good example, because I know you have one in front of you, but we're going to describe it to everybody listening. And I see those blender bottles. Everybody's got blender bottles in China they want you to sell. Let's talk a little bit about blender bottle issues, and then also let's generalize it, and just in products in general, what to kind of be careful of, and maybe how to do a little background research before you go private labeling it.
Right. So blender bottle is like my favorite prop to use, because it is
Jeff's holding up a blender bottle just so people are listening.
So it's a, it's a cool design. It's got this little this little lid that you can hook onto your backpack. It seals shut so it doesn't have any like issues with when you're shaking it. And it's got this cool little ball inside that mixes up protein powder. And it's got ridges on the side that makes it really easy to hold. So this is a great product to use. It's not a good product to sell unless you're buying it from Blender Bottle.
So explain the issues on it.
So the common issues with the Blender Bottle is that it represents every form of intellectual property you can think of in the United States. So they have a trademark on their logo, which, so this blue logo here has a trademark on it.
Does Blender
They also
Bottle.
have a copyright on that logo.
Yeah.
They have a design patent on these ridges here.
Ridges
they have a
on the-
design patent on the hook here for connecting to your backpack. They have a utility patent on the ball, and they have a design patent on the entire bottle as a whole. So if you go to sell this product, you're breaking every single intellectual property law in the United States all in one fell product swoop. So it's great product. Buy it directly from them or license it from them if you want to sell your own version. So it's that's my word of advice for that. So what do those words mean that I was talking about? Copyright is it's the simplest form of IP protection. Copyrights cover words, images, anything that you design yourself. Pretty much could be music. It can be TV shows. Anything of artistic expression generally can be protected by copyright, and those are with the Library of Congress. Trademarks is the United States Patent and Trademark Office. That covers brand names. So it's designed to cover the origin of a good. So FeedbackWhiz is trademarked. That's y'all's trademark. Blender Bottle is trademarked. We have a trademark on FRS for our law firm and on our logo. So, just goes to show you what can be trademarked. And then design patents are pretty, is a form of patent protection. It covers the design. It's pretty self-explanatory. So ridges on the side of the bottle that look in a certain way, those are covered by design patent. Utility patents are the most broad form of patent protection, and that covers functionality and usage. So the Blender Bottle ball inside, this little ball that is part of the Blender Bottle, has a utility patent on it. So, and it also has a design patent too. They've got multiple. You can have both. What that means by them having a utility patent, though, is that you can't just simply change the look of this ball and throw it in another bottle and sell it. They actually cover any spherical object that's used for mixing, whether it's made from wood, plastic, or metal. Any material is protected by their patent. And so you could make another sphere out of something else and you'd still be violating the Blender Bottle patent for this ball.
I was actually asking Jeff, I said, okay, what if I made a plastic sort of rod from the top of the screw-on lid that had sort of a ball on it that would blend, because now it's not sitting by itself down in the mixer. And Jeff goes, wait, that's covered. So tell him how that was covered by somebody else, Jeff.
So this one's covered by GNC.
GNC.
So GNC makes a knockoff Blender Bottle. That's exactly what Rob described. And they've got a patent on this. So it just goes to show you that patent can be, just because you're not violating one patent, you got to watch out because there could be more. So patents are unfortunately the hardest thing to do a search on. And that's why you pretty much, the best way to do it is to hire a lawyer. We have a patent lawyer on our team. Like I'm not a licensed patent lawyer when it comes to utility patents. So I don't handle the utility patent claims when it comes to, doing searches, because you have to watch out for so many, basically hidden pitfalls. So when the benefit of using a patent lawyer to do a search before you launch a product is that if they give you an opinion letter saying that this product doesn't infringe, then that's considered evidence if you ever were to be accused of infringement that you did your due diligence. Whereas, unfortunately, like I've seen lately on some of the seller forums, that there are people from Fiverr that do patent searches for like $7 to $25. That's not evidence of due diligence, and that doesn't hold up in court. You can't say, but this guy from Fiverr did my patent search. It doesn't work. So
they're not a licensed attorney, correct?
Correct.
Most likely.
Well, oddly enough, you don't have to have a licensed attorney to do patent.
Oh, that's true.
You just have to have a licensed patent lawyer, someone who's a member of the patent bar.
But let's face it, if I want a piece of paper that's going to give me reassurance that it was done correctly, I want an attorney's letterhead, somebody who's gone to school, understands it. So just some advice I think we're going to give out then. So kind of to prevent, counterfeit type issues or patent type issues. If you're in China, I would usually recommend get as much information you can on the product, photos, descriptions, pricing, whatever you want. Maybe even get a list of several items. Maybe come back, do a little research yourself. But if you're going to go gung-ho into a product that you're hoping to make, hundreds of thousands to millions of dollars on, spend a few dollars to have somebody like Jeff or another firm or somebody go basically research this for you and give you the reassurance that you're all in on this and it's safe to do.
Correct.
Is that safe to say?
Yeah, absolutely. Because a couple of dollars up front is much less expensive than the cost of, because, we've got one seller that we're working with right now, and it's unfortunate because he was shut down for patent infringement and his product does infringe. It's literally hits every element of the patent that is in question. And so now he's got thousands of units of inventory that he's sitting on that he can never sell. He can't sell them on, just because you can't sell them on Amazon, it's illegal to sell them in the United States. So he can't sell them on eBay, can't sell them on Walmart. They're just, at this point, they're going to have to be destroyed. And it's unfortunate because they've spent thousands of dollars to get those units. So it's, it definitely, before you, go gung-ho on something, you want to do your due diligence there and make sure it's safe to sell. One simple thing you can do yourself, trademarks you can search yourself. So go to the uspto.gov, use the trademark electronic search system, type in the names, type in, different companies, see what trademarks they have. Like, for instance, Lego has a trademark on the minifigure. This is affecting a lot of retail arbitrage sellers right now because Lego's in a dispute with OYO. And so when they go to sell, I guess it's OYO or OYO, I don't know exactly, but it's the OYO makes sports figure minifigures that are compatible with Lego. But the problem is that Lego's saying that they infringe on the Lego trademark of the minifigure. So trademarks can be beyond just phrases, words, and slogans. They can be things like minifigures. The Coca-Cola bottle is trademarked by Coca-Cola. So that shape of that bottle is trademarked. So you can't go sell a product that looks like a Coca-Cola bottle in the United States, or else you're violating that trademark. So lots of things can be trademarked. Patterns, Louis Vuitton, that checkerboard pattern, or the LVs, those are all trademarked as well. So things, you really got to watch out for stuff when you're sourcing. Because we see some sellers have come to me before and they're like, oh, look at this amazing, design I came up with, and it's a unique private label product. And I'm going to go ahead and put the Burberry print on my packaging because it looks cool. That, not that it doesn't say Burberry. They're not trying to make it look like Burberry. I mean, they are, but they're trying to make it just look high end. Or Tiffany blue. Like, you can't use the blue box that Tiffany sends their products in. That's trademarked. So you have to watch out for those sort of little pitfalls. And so it's just, there's so many things, but you can at least get started by doing it yourself a little bit to just do basic searches and knock out ideas.
Yeah, I think I remember in the day, T-Mobile, didn't they trademark their pink color or whatever they use or something, right?
Yeah, they do. They have a trademark on that.
Yeah, that's just crazy. So anyways, what we're getting at is, if you're going to build up private label brand, go through the different steps. I mean, get a hold of Jeff and look for basically protection of your brand. And that's basically what you guys are offering, right? Is brand protection. Yeah. Why don't you kind of go through some of the different services you guys offer for Amazon sellers?
So we tried to create, an all-in-one law firm that is really your single point of contact. So we've got an intellectual property attorney who does trademarks and patents. We've got Paul Rafelson, who does the tax and corporate. So like mergers and acquisitions. He used to work at Walmart and handled different, billion-dollar mergers that they underwent in terms of acquiring, Jet.com. So he was part of that team. He worked at Microsoft when they've acquired Bing. So, he's got a lot of experience that we've put to work for sellers when it comes to buying or selling an Amazon business. Most people also know him because of the tax world. He helped, Marketplace Facilitator is largely a result of Paul Rafelson. So that's why you don't have to worry about paying taxes anymore on the 20th of every month to 30 different states. And then myself, I handle all the Amazon suspensions, Amazon strategy, anything Amazon related that's e-commerce, it's nothing too big or too small for me to handle with a seller. I'll take on the easy cases all the way to the complex cases.
Yeah. And let's also mention that, I mean, we're not just talking about Amazon. You guys also handle Walmart, eBay, Shopify issues, right? So it's not just that.
Exactly. Yeah. No, we're true. E-com Attorneys is our website. We do all the platforms. Of course, most sellers are on Amazon, but it's, but yeah, we handle, right now I'm also working on a Etsy claim right now, a suspension from Etsy. So it's kind of, we run the whole gamut.
Yeah. Well, yeah. I'm assuming you got something placed to, let's say, I mean, this is something we hear a lot at FeedbackWhiz, and we obviously have a tool to alert people, but hijackers, like people hijacking your listings, is that something you guys handle, and what kind of process you go through for that?
So hijacking is an interesting one. We give a lot of guidance to sellers on how to handle it when it happens. Earlier today, I had a conversation with a seller about how one of their competitors had basically infringed on their copyright and their trademarks. And even though they didn't jump on their listings, they basically stole all their images and, product designs. So, hijacking is a broad term in the Amazon circuit. Sometimes you'll have people that join your listing and, it's a Chinese knockoff product that's not even anywhere close to yours. We give the guidance on that as well. So hijacking, it just depends on the situation. There's no blanket response on how to always handle it, but we give guidance to sellers to help them figure out the best course of action.
Yeah. Sorry. So what do I do if I see that the company that I'm getting it from that's enforcing the map isn't following their own map? I mean, obviously I contact you, but what kind of process involved? Should I try contacting them first or go straight to you?
So you can contact them first and see what their plan is. Why are they not following map themselves? Map is kind of a really touchy legal issue because in certain states, it's unenforceable. Like you can never have a map agreement. That's considered price fixing. A lot of times where companies get that wrong is they will make companies sign map agreements, and that's like a huge, red flag. So what we help sellers with, recently we had a wholesale client who is a wholesale for many brands, and the company they were buying from was a sports nutrition company. They started selling products below map on Amazon, and then reported that, reported all the unauthorized sellers as selling counterfeits. And so we stepped in and we reached out to that brand and we talked to their lawyer and educated them on how, brand registry is not where you remove an unauthorized seller. It's, you can't say someone's selling counterfeits just because they're below map or just because they're not an authorized seller. But that, it got into a really touchy area because of the fact that map was involved, and map it can be an antitrust concept. So sellers have to watch out, because if they reach out to the brand and say, you need to raise your prices, that could be construed as antitrust. If the brand and the sellers agree to fix prices because they signed a map agreement and it's a signed map agreement, then that can also be antitrust. So map is it's one of the areas that people think is the easiest thing in the world to do, which is why you have so many brand enforcement companies out there now that are not, not following the law. But it's one of the most legally challenging areas for a company as well. So for retail arbitrage sellers, it can actually be really beneficial to point out where map is being done wrong. Usually is one of the best ways we help retail arbitrage sellers when a brand does violate the line. So it really should be handled by lawyers, in my opinion. Yeah. You could reach out though first and at least just try to see what's going on. A lot of times they won't talk to you though, because they don't want to create that de facto agreement.
Yeah. Yeah, no, that's good information, and something that I don't hear a lot of people talk about, but I've heard those questions come up. So, because I mean, in the Amazon world, we're dealing with so many, different people, retail arbitrage, private label, just resellers in general. I mean, there's a lot of different stuff going on out there. Now, what about somebody, let's say that I've got a private label, it's up at selling on Amazon, somebody jumps on the listing, and I've heard, unfortunately, I've heard this, and I know you and I have talked about it before. People run out, they get they create their own letter to send off to the person to try to get them off the listing. And basically, you've told me, and I totally agree with you, that's not the right way to do this. And they find some what they think is a legal letter on the internet, and they send it out. Let's talk a little bit about what is some of the issues you can run into trying to handle it yourself and misconceptions out there versus just having an attorney do it and do it right?
So when we do it as an attorney, we send out a thorough letter. It's on law firm letterhead. It's got all the laws that are being violated, examples that say why we're right, and basically send that out. And we usually don't send it by email. It's usually sent by UPS. So that way it has more authority and more force. When sellers do DIY, it usually is full of errors. So like one seller I was helping this week sent me a cease and desist letter that she received from a brand. The problem is that the brand just filed for their trademark in December and used the serial number in place of the registration number and was demanding damages. Now, as any private label seller will tell you, the most agonizing months of being a private label seller is the months between when you file for your trademark and you've got just a serial number, and when your trademark registers and you get a registration number. So that company that just filed for their trademark has absolutely no rights until it registers. And so sending out cease and desist letters themselves, it didn't do anything because we didn't even bother to respond, because once we saw that they have no trademark interest, there's really no point in even bothering to, it would cost the seller more money to respond to them. So we told them just throw it in the trash. There's nothing they can do. Yeah. So it's, but writing it yourself, you run into those risks because what you might think is the law, your understanding might not be completely accurate. And all it takes is the other party receiving one of those letters to take it to a lawyer, and you'll find yourself either being ignored, or worse, you could actually be sued for, tortious interference or some other claim that they might hit you back with, because you might be enforcing rights you don't actually have. Yeah. When it comes to cease and desist letters, for private label products, usually that if you're having an issue with hijackers, the best course of action we're sending people these days is to transparency, because transparency allows you to control your supply chain and make sure that only your products show up on your listing. I know it costs 5 cents to 25 cents per product extra because you have to apply that sticker, but it's the easiest way to make sure that your manufacturer is not selling factory seconds out the door that end up on your listing, or that somebody else is purchasing your product from a product that looks like yours from Alibaba and sending it to your listing as well. So transparency actually does, for private label sellers, really help in that regards. Yeah. And it's the cheapest solution.
Yeah, one solution that Steve Simonson had suggested, and he's done a lot of manufacturing, is if you're doing a mold, for instance, have them imprint your name or your trademark or your logo, whatever it is, into the mold.
That's perfect.
Yeah, that usually helps. Now, it's not that they couldn't fill that area of the mold in and still make extras, but at least it cuts it down, the possibility. And also signing an agreements with the factory, that basically says that, you're exclusive to this product, and will they make another copy of it that's not? I mean, yeah, they probably could, but at least there's some there. And then the other thing I want to bring up regarding the letters is that it's not a one letter fits all. Like each time somebody violates it, it could be different. So just because you go to Jeff and he gives you, he sends a letter out and obviously gives you a copy of it, doesn't mean you should take that letter and just use it every time like a blanket one, because each time it's going to be different. Isn't that right, Jeff?
Absolutely. Yeah. No, we recently sent out a cease and desist letter for a client, and because the person had ripped off all their product packaging designs and even was using their name and one of their trademark terms on the competing product name. So we sent off a cease and desist letter to the seller, but you wouldn't be able to take that same letter and use it again, because all the details that we wrote for this 5-page cease and desist letter that was sent out were surrounding how this product A made by our seller had all this intellectual property, copyrights that were registered copyrights, registered trademarks, and product packaging with registered trademarks and copyrights. And that product B by the offending seller was violating all those. And we had specific examples showing, here's our copyright and trademark, number for this. Here's what you're saying, you're using our product name on your packaging. Like that's direct, but he wouldn't be able to then take this and apply it to product C, because now it's a totally different product, unless he goes through and does that whole analysis, or else it's going to look funky. And it's also no longer going to be on law firm letterhead either. So because it's just going to be coming from him, even though it's written by a lawyer, it's not going to be as strong when it doesn't have our letterhead at the top.
I think that's a bit of advice you just gave. If you are taking Jeff's letter and rewriting it, take off their letterhead because it didn't come from them. So
yeah, because now
violating another issue.
Yeah, that's forgery. And believe it or not, you know, we have had one instance where somebody called to verify a letter that we supposedly wrote, and it was actually Amazon, and we didn't write it, and we didn't verify it, and that seller is no longer selling on Amazon. Yeah. So, you know, you can't just, you know, hijack a lawyer's name and use it and think that it's going to work. You know, people do call to verify the phone number at the top of the letterhead and the phone numbers on our website.
Yeah. I mean, and the reality is, I mean, anything legal is going to be usually a little expensive, but you got to think about in the long run what it could cost you by not doing it.
Right. Absolutely. And also, if you're building a business to sell, which most sellers are building a business to sell, you want to have proper trademarks, proper copyrights, proper patents, because all those things, like, yes, they cost more money when they're done by a lawyer compared to DIY. But the reason why General Motors and Ford and Coca-Cola have value is because they have such goodwill that was produced over the years and such strong intellectual property portfolios. So if you're not going out there and getting that strong intellectual property portfolio, or, you know, the proper, you know, LLC agreements and the proper, you know, cease and desist letters, then your DIY company will never progress to that next level when you want to go and sell it, because you don't have those foundations to sell them.
Yeah. And full disclosure, I have paid Jeff to do help me with a couple trademarks myself.
Yes. Yes,
so even though I currently do not sell on Amazon, as another full disclosure, I do not sell on Amazon. But Jeff, I had a few trademarks that I wanted to keep, and Jeff helped me with that, and I did pay him to do it. So, but let's talk a little bit. I just want to make sure everybody knows, so they don't, you know, they understand full disclosure here. Yes. But let's also talk about, like, Jeff knows a lot about Amazon, and there's a reason I've had him on before and why I have him on again this year. And Jeff, talk about your background of selling on Amazon and where you kind of came from, and why you have, not only as an attorney, but a little better understanding. I'm not going to say as other attorneys, but you just got a little better understanding than some.
So I've been in the Amazon ecosystem. Thank you for that. It's a good intro. I've been in the Amazon ecosystem since 2011. I actually opened my seller account roughly 2 weeks after the switch between when they used to have daily payouts and every 2-week payouts. So I was 2 weeks late to the party. So I have every 2-week payouts on my seller account, but I've had that account since 2011. And it's, and so that's how I paid for, like, I bought my first MacBook in college with selling on Amazon. And then I eventually paid for law school by selling on Amazon. So when I was in law school, I'd grown my Amazon business. I have a Vendor Central and a Seller Central account. I grew that to 7 figures. And that's how I paid for law school. And then now, as an attorney, I still help some brands who want to sell on Amazon, but it's obviously I'm more focused on helping sellers. But the great thing about having had all this experience with selling is that I know about detail page creation. So I understand the technical side, but I also understand the legal side. So one of the brands I helped design detail pages for is an animal health company. And so I got to wear the SEO hat of helping make sure their, pages were optimized for conversions, but then I also got to wear the legal hat to make sure that they didn't violate any FDA laws. So it's kind of a cool best of both worlds that I've been helping, sellers with. And so when sellers come to me and they have an issue or a question about Amazon, it may not even be anything legal related, but I usually have a pretty good understanding of what's going on because I've been in their shoes.
Yeah.
So.
Absolutely. Which I mean, to me personally, personal opinion, it makes a difference. Having somebody who's been there in the trenches, sold on Amazon, understands the headaches you're probably going through, may even have experienced it themselves. Yeah. It definitely helps to have somebody who, understands it and has a way to basically deal with it legally and get you going the right direction.
Thank you. Yeah, no, I mean, when it comes down, even like FBA, when I talk to my retail arbitrage clients, it's like, I prepped and shipped to Amazon when I added it up from law school, 250,000 items that I was there putting FBA stickers on and sending off to Amazon. So
yeah,
it makes a difference because when they come and they're like, you have no idea what this is like. I'm like, no, I do. I understand it. And this is how we can help make sure your business is better. And sometimes some of the things I'm able to share are not anywhere law related, but they're just practical tips on how to make the operation run smoother. Like they can be faster to to get folding tables in your warehouse. If you get folding tables or rolling tables in your warehouse to line items up and work from left to right, it's faster than getting circular tables or random, using random countertops in your garage to try to do things. A $10 folding table, buying 5 to 10 folding tables and lining them up your driveway can be so much faster than just sitting there with one little tiny, desk that you're trying to bring stuff to and label products to get out the door.
Absolutely.
So since retail arbitrage, I don't know if you know the saying, in today and then out the door by 4, or out the door in 24. So I used to practice that too. So
yeah, that's awesome. And remind me again, because it's been a little while. As far as a law firm, you guys can handle any state or certain states. Remind me again what you guys handle as far as that.
Yeah, so we can handle, most of the Amazon issues are federal law. So we can handle federal law in all 50 states. We work with a lot of international clients as well who have issues in the United States for tax or company organizations. And then when it comes to state law issues, we can work in California, Illinois, New Jersey, Connecticut, and Florida presently, and Virginia as well. So those are the states that we've got covered in terms of state law. So at least all the major markets right now for Amazon sellers.
I mean, just so everybody who's listening understands, there's other attorneys out there that also have a good understanding of how Amazon works. Jeff and I just happen to connect. We talk all the time, and we're always talking about things, or if somebody contacts me, it's having an issue. So we're not trying to say Jeff's the only option out there. I just happen to be friends with them, and he gives some great advice, and he's willing to come on the podcast. So that's always nice. So Thank Jeff, you. Let everybody know how they contact you, how they get a hold of you. And, I think you have a Facebook group now too. Go ahead and cover that. Yeah.
So we've got our Facebook group right now. So I've got a Facebook page that I just set up a couple weeks ago. So it's facebook.com/Schick Jeff. So the name is down at the bottom of the screen, but it's SCHICKJEFF. That's my Facebook page. If you want to add me, I've still got my personal page. Sellers add me there all the time. Add me on any of them. I'll accept it for the most part on all of them. And then, and you have the link to the personal page if you want to copy that to. Or just literally just Google his name or try ecomattorneys.com. I mean, that's another way to get a hold of Jeff. He's always out there in the community answering questions and helping people. And definitely, get a hold of him if you have a legal issue. Again, a kind of any e-commerce platform issue that you're having, get a hold of Jeff on that. Yeah, thank you. No, I mean, like I said, we've been helping with more and more, we're helping with eBay sellers now. Etsy was the new one, intellectual property infringement on Etsy yesterday. So the first case I'm working on for that, which is quite interesting to just see how these different platforms function. And then of course, Amazon, we can handle almost anything on Amazon.
For sure. So. Well, Jeff, thanks again for being on the FeedbackWhiz podcast. I really appreciate your time, and we'll have you on again, I'm sure, next year, or if something comes up sooner.
Definitely. Sounds great. Thank you very much. I appreciate it.
Thanks, Jeff.
Thank you.
Please subscribe to our YouTube channel, and for more information, please visit feedbackwhiz.com.